So my name is Giovanni Sileno. I'm a researcher from the Socially Intelligent Artificial System Research Group at the University of Amsterdam. And well, my talk will be very much in overlap, often complementary, I hope, with respect to what Mireille just presented before. So I will argue, if you want, against what is the current view on technology, of legal technology. I will try to argue for a new design level to introduce for computational artifacts. So let's start from the beginning, the types of law. That is just a continuity in a way from the presentation of Mireille. And I will go, rather than making the differences, in this case, I will try for a more nuanced distinction, let's say that in this way. So we have text-driven law, data-driven law, and code-driven law. So you already heard about that just before. So the text-driven law, it's the normal way in which we think of law. So that's a legal activity which is performed by humans by means of sources of norms, such as statutory law or case law. Then we have data-driven law that applies statistical or inductive method in order to do automated decision-making or decision support. Then code-driven law, which is about articulating in computer code some legal norms on policies. So the main argument of Mireille is that the text-driven law is distinctive from the others because it is open texture and it has multi-interpretability. And so it can inherently be contested. While on the other hand, for data-driven law, we have statistical closure. For code-driven law, we have some type of logical closure. So in principle, we should be out of the problem of contestation because we know that these systems are deterministic. So, I mean, they are going to do what we expect them to do. So that's, we could say that these two types of laws within codes, they are promoting legal certainty, but very much is unknown about the principle of justice, like proportionality, distribution, or also instrumentality. So do they take into account what are the contextual policy goals? So at best, by accepting that, these type of instruments, we are going to have computational legalism. So, but I would start, to reduce this type of distinction by noticing that we don't have actually text-driven law, because as far as humans are involved, we should talk about text-guided law. Then again, data-driven law, if that's just directly used, then it's data-driven, but if there are some human in the loop, perhaps we should call it as well data-guided law. But then if we look how these systems are built, and let's consider, like, without loss of generality, a typical training data set for supervised learning. So we have instances, and we have a label. Then we know from practice that there are critical questions that are made. So like, is the training data set representative of the domain that we are going to, in which we are going to utilize these decision-making algorithms? And is the labeling rationality remains the same in time? So, or there are different people that are labeling, so there may be other underlying mechanism into it. And also there are questions about whether the training method is accurate, is robust, and etc. So in principle, in practice, statistical closure can be contested. And something similar we can say about logical closure. We can imagine that's made by rules and facts, and then we have similar critical questions. So have I considered all the relevant rules? Have I considered all the relevant facts? Is the formalization correct? Is the reasoning total robust? So again, we can contest logical closure. We can contest code-driven law. So the computational legalism ideal actually works only as far as we forget all what may go wrong. But in practice, we know that things can go wrong. So is this all? I mean, we could close at this point the presentation. We don't have any hope. Well, no, there are people that are even more optimistic in the sense that they say that, well, we could, in a certain way, formalize the principle of justice in some form of meta rules. We could also make explicit the policy goals for the instrumentality axis. But can we sure about any formalization? Well, for the same problem as before, the answer is ever. I mean, we don't even have to consider the problem of how to formalize, even the content of what is formalized. It's always discussed. So we cannot truly be concerned to be secure that our formalization, I don't know, universal human rights is going to be the correct one. And also for the policy goals, well, we cannot expect that a policymaker will make explicit all the policy goals because certain of those, they are on very highly contextual issues. So it's kind of very optimistic to think so. So what does it mean? That the computational justice ideal assumes perfect conceptualization, but this is not real. So what we remain with? Almost nothing, in the sense that the computational legalism ideal works only as far as we forget all what can go wrong, and the other one assumes perfect conceptualization. So let's just accept the opposite. Let's start build up our perspective towards technology by starting from the opposite assumption. So let's consider that all things may go wrong at all levels. So that means we need to accept that people should be able to appeal to any decision-making mechanism. On the other hand, let's accept that we need to integrate systematically new form of knowledge into our algorithm that could be given by higher order courts, jurisprudence, or other normative sources. So this means that we need courts to be able to quash. So as there is cassation in the legal system, so it's something similar. You have an algorithmic decision-making, so courts can go over it, override them. And I put also other actors, because in principle we could imagine also other computational actors that are doing that. So they are looking what the other algorithms are doing, and they say, I can appeal against you because you're not behaving as you should, or I can quash you because I have higher normative power with respect to you. So if we accept this way of looking at the problem, then that means we are moving towards code-guided law, which is an ecological system that includes interface with humans, which may be derived from legal norms or from other methods. But the important point is that this is the lowest authority possible with respect to human authorities. So the end part of this first part of my talk is that a serious technological gap exists today, also because we start from the opposite perspective of that. So we assume either computational legalism from a technological point of view, either computational justice. I haven't seen any technology that is starting from the completely alternative way of looking at the problem. And then where the concept of normware kicks into. So what is normware? So all people that have some computational, I think even normal people, common people, they know something about what is hardware and software. So hardware is a physical device, what's running, produce a physical process, and that's situated in a physical environment. Software is a symbolic device. When it is running, produce a symbolic process and relies on physical processes. So eventually there will be some hardware that is running the software. So what normware may be? Well, that's this part of the lecture will try to convey that. What is important here, that there are two dimensions that for me are interesting to go deeper. It's the artifact dimension and the process dimension. So let's start from the first one. The first meaning that we associate any person that read normware and think of normware, what may be, is as artifacts, which are directives concerning regulation. So this is a human natural language way of looking at it. You need to imagine that expressed in a computational form, but something like the cookie jar must be full, or you are prohibited to eat cookies, or you cannot eat cookies, for instance. So there are statements that are about regulating situation in the world, like a cookie jar, or about regulating behavior. Now, we know from the technological literature there are a lot of different ways of specifying norms. We can go from access control policies, like I deny access from any type of client, but from the people coming from example.org. There may be languages based on the ontic logic, based on the author primitives, but actually we don't need to add the normative specification explicitly, because programs in themselves, they are already mandatory. So in imperative programming, if I write A is equal to true plus true, that means the system has to perform true plus true. So there is an implicit must. And similarly with the queries in declarative languages. So, but there is another type of directive that generally is eclipsed by looking at normware or just directives about regulation, which is directives about terminology. So when I have this type of rules, there is a need also to define what is a cookie, what is a jar, what does it mean to be full, who is you, what is eating. All these things need to be defined, otherwise I don't know what does it mean, your rule. So typically this is done implicitly, in, let's say, in simpler form of a normative specification, but in complex world, you need to provide this type of knowledge. But we also need, if you truly want to apply this type of knowledge, you need also practical knowledge about the world, like eating cookies. That means that cookies are destroyed and the jar is not full. Why we need so? Because that's the only way in which we can connect some way the consequences of action, which is necessary to have responsibility attribution. If you don't have any mechanism that is using responsibility attribution, so that means you're not truly applying this normative specification. But I will insist on another layer of the problem, because so far we just looked at the internal perspective of Normware, so what's within, what's written into the code. But we can take devices just because they are meant to regulate, without even looking what's inside into them. So a door regulates entrance, and semaphores regulate traffic. So this is what we can see, and even if we don't have access to what is the logic behind it, or why a door is open or not, we know that's regulating. So we can see it. We can see that there is a regulatory function there. We can say that same for machine learning modules. Because if I see the cat classifier, well, is this a cat? It's answering to that question. So it's kind of regulating what means to be a cat, according to how it has been built. And the same, that's a reinforcement learning algorithm. So it's saying what is the best action to perform in a certain type of environment. So from a functional point of view, also black box modules, like the one of machine learning, they are part of Normware. Now I can pass on the second dimension, which is Normware as process. The starting point is regulation as control. So whether it is artificial or natural, designed or emergent, there is only the same fingerprint for all control system, is that there is some type of reference, which is the target of control, and then that the entity is set either to approach or to avoid. So that's the direction of control. So I have somewhere, and I have an attitude towards this somewhere. So I have a space, I have a kind of behavioral situational space, I have a current state, which is a point into this dimension, and I have a target state, which is another point, and then I try to trace a trajectory towards it. So, but now I'm returning to the point of before. So what defines what are the references though? So what is the final state? How I define it? Or what is the current state? So how I'm going to define it? So I went the other way. So we enter into the problem of undetermination. So that's related to the ambiguity problem that Mireille was saying before. So the references are by their own nature indeterminate because different perspective of participants, they can see at the same object from different point of view for several reasons. And then that means they may have different behavior or situational points from which they're computing what needs to be done. So that means we cannot truly overcome that. This is part of the system as well. But because we have indeterminacy of references, then we have also indeterminacy of directives. But there is another source of indeterminacies, which is the antinomies. So I could have in the same system two directives that are saying the opposite. And that's also introduce an indeterminacy. So that means we need, at systematic level, mechanism of conflict resolution. Because we need to accept that conflict is just systematic. It's not it's a feature of the system. So let's see what does it mean in practice. Let's look at the very basic functioning of a control system. So this is first order control. There is someone that is saying, do that, and there is someone that is doing that. We can interpret that in code-driven way. So this goal could be an instruction, and then there is a computer that is doing it, or even in the data-driven way. So there is a labeled data set that is giving an idea of what I expect you to do as a machine learning black box. So in both cases, there were other black boxes that were possible, like potential candidates instead of that action that has been performed eventually. So that means there is some rationality that allows to do that. But where the goals come from them, we don't know that from that picture. We don't know where the goals come. So that's why we need to add depth. And we look at the second order control. So we can separate strategic goal from tactical goal. And again, we know that there was a pool of goals, of tactical goals, amongst which we utilize in order to take that. So in previous work, a couple of years ago, 3 years ago, we showed that essentially the problem of machine learning today, all the problems of trustworthy AI, explainable AI, can be understood because this architecture, they miss the strategic goal component. It's all about data set, and just how the machine is operating. You don't have another layer of control behind that, and that causes all the problem of trustworthiness and explainability. But this also corresponds to the cybernetic view of systems. These are the 3 levels of the second order cybernetic system. So you have policy, intelligence, and operations. Policy sometimes is also called identity, because again, it's associated to autonomous agents. But this takes a specific view over computational computers that's about a single organism. It's not about an ecology, it's about an individual agency. And that means that we are considering as an assumption a totalitarian architecture. This is not wrong, but I mean, it has consequences, the fact that you're taking this perspective with respect to technology. So we need to go beyond that. We cannot accept that, we can accept that technology is only taking a totalitarian view of how it is designed. So we need to acknowledge that there are several autonomous entities. How to do that? Well, let's just accept there are a lot of them that are saying what needs to be done, and at all levels, tactical and strategic level. Then that means also, as I said before, we need resolution mechanism. The interesting aspect of resolution mechanism that in themselves, they can be contested, and they have several levels why they have been decided all over the place. So this is actually a design problem. That's what I'm saying when Normware is another type of design for artificial devices. We're not caring whether it's a data-driven, whether it's a code-driven. We're just looking what is the role in the coordination system that is expected to be done by the machine. And this would be a participatory architecture, let's say the more complex form of Normware that we can see. And I think where we should strive as technologists to work towards. And indeed, I've been interacting with this concept, talking about the internet infrastructure. So there is a proposal of responsible internet that arrived 1 year ago. And I found it was a super fascinating topic because as a computational infrastructure on the internet, you know there are users, there are networks operators, there are governance bodies. They all want to play a role how the internet function, and they have legitimate reason why to do so, but we don't have a technology allowing them to do so. So I've ended my talk with a less tentative ontology. So Normware would be a coordination device. When it is running and adopted, it creates a coordination process and relies on symbolic, possibly hard-coded processes. So perhaps a key point for conclusion, or?
Yeah, this is spot on. It's 15 minutes.
Can I? Yeah, that's just the slide. So my key point is that there is a continuity between institutional computational activities. We don't need institution to become more mechanical, but institutional constructs needs to be designed within technology. And as we have a plurality of normative sources, then we need a plurality of computational normative sources. So that's why the concept of Normware is needed as a truly another level of design. So, in other words, even more simpler, for me, the contemporary socio-technical challenge that we have is not about mechanizing law, but yes, it is about introducing legitimate normative process within the computational realm. Then we see that there is a role. It's not about code-driven law and data-driven law, but it's both about developing the Normware way of looking at technology and Normware-centered type of tools, and lawmakers, policymakers, citizens. Thank you very much for your...
Thank you. Laurence Diver, the floor is yours.
Hello. Hi. Thank you, Giovanni. That's fascinating, and I think your conclusions are something I can entirely agree with. I'm just not sure about how you get to them. There's tons of ideas in the paper, lots and lots of kind of kernels of thought that could be pursued, so I can't cover them all here, of course. And I see quite a lot of parallels with my own work and the idea that we ought to be looking at design as a practice to try to assess these systems. So what I'm going to do is, I've only got 10 minutes, so I'll limit my remarks to highlighting two of the core messages that I took from the paper, and also to identify some concerns that I had from a legal perspective. Right, so of the many points, fascinating points that the paper makes, two of them kind of stand out for me. On the one hand, you highlight the challenges and the limitations of formalization, particularly with respect to legal institutions. And I think that's absolutely correct. I completely agree, and it connects very much with what Marie was just saying in her keynote. I've written before about how attempts to formalize legal institutions might be committing a category error or attempting something that's a category error. So on the one hand, you highlight these challenges of formalization, and then on the other, you introduce this concept of normware. And as I see it from the paper, you seem to present it from two separate angles, or you present it as having two separate kind of characteristics. On the one hand, it abstracts away the differences between code-driven and data-driven systems, which I think is valuable because it means that we can focus more on the broader ways in which computational artifacts generally regulate our behavior and our expectations and our action. And then on the other hand, at the same time, you also frame normware in terms of questioning the internals of the system. So looking at the design of them, and you divide that into two sections. So the idea of hard-coded CPU instructions, which you call first-order directives. And I think that's really interesting, getting down to the bare metal of the machine. I think that's a fascinating finding. And then on the other hand, second-order directives, as you call them, contingent instructions like permissions, access control lists, that kind of thing. And for you, they guide execution rather than controlling execution. I think this idea of unfolding design in that way is extremely powerful. Systems are not monolithic, they're not black boxes. Often lawyers tend to think of them as things with inputs and outputs, and they don't look inside, and I think what you're doing is really great from that perspective. So the guiding aspect I really like. I think it's important. It's a fantastic goal. Those are my kind of bird's eye things that I take from the paper. But it connects really to my first question, which is how you actually define normware. Because I can see at least three potential, from my perspective, from a kind of legal philosophical perspective, I can see at least three potential ways of framing it. Is it a description of existing systems? Is it a theory of how existing systems work? Or is it a strategy for guiding how they ought to be made in future? And the difference is quite significant, I think. You refer to adopting normware, for example, which would imply it's a strategy. It's something we want to seek to do actively. But then you also refer to systems that could be described as normware, which might imply that they're already out there and we're now going to identify them as such. So once the definition is a bit clearer, that leads to my second question, which is who or what is the target of normware? So who's the addressee of these norms? And I would put it in inverted commas. And this, for me, is a persistent question throughout the paper. Again, I can see three potential targets here. Firstly, is normware directed at other computer systems or components within one computer system? So the controlling and the guiding of how the execution proceeds according to internal technical rules that are internal to the system? Or is it aimed at specifically legal tech computer systems? So computer systems that are relevant for our purposes because they are part of legal practice, part of the legal system? Or is it aimed at humans? Is it aimed at controlling and guiding behavior and action of human beings through computational architecture? Now, if it's the first or the second of these, i.e. computers, either internally, either as generic computer systems or as legal tech computer systems, I'd like you to maybe expand a bit on in what sense they can be guided in a normative way. How can a machine be guided normatively rather than prescriptively? And that says something about whether guidance is really the right word. In essence, can you guide a machine? Can you guide a machine? And if your focus is purely on the process that the machine follows in its execution, that would seem to an extent to bypass the legal concerns that we are concerned with here, that we're interested in here. It's almost like we're staying within the internal realm of the machine and not necessarily considering what's happening outside of it. And that's the point at which the execution or the performance that a machine follows can have impact on human autonomy in legally relevant ways. And that's the point at which it becomes relevant, I think, for a circle. So we're moving out of the internals of the system to think about how it interfaces with humans, and that's a phrase you just used, which I like, to consider how humans' experience is impacted by computation, or by normware, perhaps, if I'm understanding correctly. And this is where I think the concept of affordance really helps. And I know in your previous work, you've looked at affordance quite closely, and because that helps us to understand what the system does and does not make possible. And you refer also to ecology, which is connected with affordance. But it seems to me that the ecology you're focusing on is internal to the machine. It's not, whereas what I would say is that the ecology that matters is, as it were, out here, what's out here, what we're sitting in right now, from a legal perspective. And if you were going to take that view, a more kind of humanistic ecology, you couldn't take a functional view of what the system does. You would need to actually look at it and see what it in fact does in the real world, what its empirical effects are, not what's happening inside it, although the two are obviously connected with one another. So those are the concerns I have if Normware is about what's happening inside the machine. But if Normware is what's happening, if humans are the target of Normware, if we as citizens are the target of Normware, then of course that really matters from a legal perspective and from a perspective of legal protection, which is a core theme of our project and of Circle more generally. Legal protection is in part about protecting the autonomy of human beings. And this relates to how you characterize the idea of computational legalism. And now, computational legalism, as I originally coined it, was not intended as an ideal, but quite the opposite. It's a warning. It's a bad thing. And it's about maintaining a kind of constructive skepticism, which I think in your presentation you evidence, perhaps more so than in the paper. And coming back to the name of the conference, the word law is in quotes on purpose for precisely this reason. It's about maintaining this constructive skepticism, an emphasis on constructive. So what I want to ask is, what role does Normware play in that constructive skepticism, if any? Does it provide us tools for identifying, critiquing, and potentially solving the problems of computational legalism and of code-driven law more generally? And that then brings me to my conclusion, which is about your conclusion in the paper. So ultimately, you seem to be suggesting two solutions or two aspects to the solution. On the one hand, contestability, and on the other hand, some kind of new universal knowledge interchange format. And I can completely agree with contestability as a goal. I think in principle, of course, it's essential. But there's lots of sub-questions there. So you talk about implementing points of contestation. I'd love to hear more about what you're imagining there, because I can see many, many questions. Where do those points sit? Are they always ex post? So you were talking about appealing, having the role of the courts in this, but that might imply some kind of ex post contestation. Are you thinking only of ex post contestation, or are you imagining some kind of real time ability to contest within the architecture, the design of the system? How would those points of contestation map onto the procedural requirements of law as the ultimate normative system that these systems of any kind have to comply with? And that includes jurisdictional differences, because obviously it's not the same everywhere. And ultimately, how would these points of contestation be designed meaningfully? So the question then is one of affordance, like how would they be afforded? To whom would they be afforded? When? What form would they take? Because ultimately you can't contest something if you can't understand it, if you can't see it, if seeing is in fact the sense that makes sense to you. And ultimately, does your notion of contestation points, can it be universally accessible in the way that natural language can, at least in principle? Because if we're talking here about the rule of law, we're talking about the capacity to contest within the legal domain, so not within sort of an AI ethical domain or some form of resistance to computation notion. If we're talking about the legal domain, natural language, text-driven normativity is the default, and in a sense it's accessible to all of us, or almost all of us, because language is more or less universal. So that's my issues with the contestability aspect. With the knowledge interchange format, I find that more problematic. I think generally it may be, as I said before, a category error to attempt to formalize legal norms, which are institutional facts in the end, speech acts, as Marie was talking about. But I wonder what your notion is of a universal knowledge interchange format, if you have an idea of it in mind which could bridge that gap, which could solve that problem. What would it need? What characteristics would it need? What affordances would it need to have, and for whom? I like the idea, I like the ambition of it, and I'd love to hear more about what you what you have in mind. That said, it is in the end still a computation first approach. The solution seems to be one of we need better computation, not perhaps less computation or no computation at all. Which is not, I'm not saying that that's correct either. I'm just saying we can't have, as Marie's slide said, the reflex towards computation. And this kind of connects to what's sometimes called question zero. Thinking about like the problems that the solution that you're thinking of solves, the problems that it does not solve, and the problems that it may introduce. Because by calling a knowledge interchange format universal, that might imply something that we rely on it too much. And it's in fact is taking things away from us, not giving to us. But I think what you're doing is very ambitious. It's extremely interesting, and looking at the bare metal I think is fabulous. And I really want to hear more about how you imagine this developing. So thank you very much.
Thanks.
Okay, fantastic. So we have very little time. So I'm going to ask you to reply in like 2 minutes, which means...
Wow.
And I really want to take at least 2 questions here and at least 1 question from the chat. I answered the question from the chat.
Okay, so perhaps I will spend my 2 minutes just to clarify a little bit what is the sense of Normware. So I'm in between. The sense as a background, I have a PhD in AI and law, but I'm a computer scientist. I was in the law faculty, so I was used to a lot of the debates that are in the law faculty, but still I'm someone on the computational side of the story. So I engage my peers are people that are developing technologies. So I see, if you want, the limitation of both sides. And actually my attempt here is like to bring the correct complexity on the computational table of the story, but on the other hand also make clear to the legal side of the story that there may be things that are converging towards the efforts that legal system are trying, or if you want, principle of justice, are trying to have to direct where technology is going. So let's say this kind of positive effect that can have on technology. So the paper is particularly on this technological side. I'm discussing about intervention point rather than contestation into the paper, because indeed I'm neutral. What is the reason why you're intervening? But at least that I have a technology that is enabling someone else to intervene at a certain point. Because the main problem with our current technology is that intervention points are not explicitly designed. If they happen, it's by ad hoc reason. There is no map of intervention points. And this is required. So for me, the point is, if we don't want to have dumber intelligent system, even in the social sense of the story, then we need to have this type of technology. Then we may accept not to utilize technology, then it will be another type of problem. But if we accept in technology, we should have them not to create our systems dumber. And there is no other way out. So systematically, so this is my main argument from cybernetics, and actually going beyond cybernetics, we are obliged to think into these terms to see the right granularity of the problem. So with respect to your question, what is Normware? As I presented, it's a level of design. So I see that as a stance. So it's both an interpretative and a prescriptive stance. So I can utilize it as I did in the second version of the paper, to just reinterpret what already exists out there. It's an interpretative stance, but in a prescriptive sense, I can see that there are feedback loops that are missing. So as a designer, I know that I need to introduce something there. And the design can go beyond the computational aspect of the story, because indeed there are the intervention points to be designed. And this is task for legal expert, for policymaker. I cannot say, I don't want to take that responsibility. My responsibility is to create a technology that allows you to have the intervention points that you have set up. So I have just another paper at this point, a Forum of Democracy and Digital in Rome. It will be in 2 weeks, in which I worked with a PhD student coming from the law background. And the point is that you have legality, you have legitimacy, and you have instrumental possibility. So the 3 of them needs to be there, because if you have legality and legitimacy, but you don't have instrumental possibility of utilizing your legitimate points to raise a point against an algorithm, then you cannot do anything. So the Normware, it's something that, as far as I see, should fill that component. So the instrumental possibility. But legality and legitimacy is still very much a concern of legal people.
Fantastic. I can see enormous amount of questions sort of bubbling up. Michael, somebody else? One more question from the audience? Yes. And then I already see a question also in the chat. I can see it myself. Michael, can you give me your first name again, Mr. Zul?
Jambin.
Jambin. So Michael Jambin and Bernard.
Hi, thanks. Michael from UCL. I may misunderstand, so apologies if I do. When you build something that we could call Normware, you still have to build it on some kinds of technological foundations. If we look at the way the internet has been built, the design principles of the internet, these famous openness, end-to-end redundancy, interoperability, these are still very value-laden ideas. And Corinne Kath's recent PhD thesis in it really emphasizes this in the IETF and similar places. We can also see alternative visions of underlying infrastructure. Look at Apple building a very vertically integrated system. They say, we need this for security. We couldn't possibly remove this. We built a Jenga tower. Security and privacy are very, very important. We can't have solvable systems. So I'm wondering, in Normware, is there a very low level of value-laden, almost kind of constitutional style norms you have to build in order to allow this contestation? And if you do, what might those effectively be, and how would we, when these are contested, how do we have contestation about these?
But again, this is the choice of the designer that is implementing that. So the normware will be the stance by which, we need tooling, we need models, we need ideas, we need patterns to utilize reusable components. Then how you're using them depends on the specific type of application. So if the internet needs this type of infrastructure or intervention points, then the normware that has been described for the internet, you should visualize the system by this criteria, and then you can evaluate whether indeed these intervention points were satisfied or not. So there are situations in which you may not need to utilize the concept of normware, which is something that I write into the paper. So if I'm talking about a Turing machine, it's so low level that I can apply, and I do that in the paper, the normware level, but it's not the correct stance to see the problem, because I don't need to think about contestation at that level of computation. I could, but it's not meaningful. While in situations like internet, well, it's much more important that I do so because I want to work on this level of contestation points.
Thanks. I'll let other people ask questions. Thank you.
Okay, I think this raises even more questions, but we have coffee breaks and lunch breaks for that.
I'm jumping in from University of Cambridge. Thank you. So Professor Simon Deakin at Cambridge Law Faculty in 2002, he has a paper about legal memetics. So he basically raised the 3 layers of evolution from like the genetic biological evolution, and then to memetics, basically a symbolic linguistic evolution of words or languages. And then he raised the 3rd one, the normative realm of norms evolution. So when I saw these 3 layers, it just brought me back to that point of, like, from an evolutionary perspective of like legal systems. So like law itself is, like you also said, like the normware is based on software, kind of symbolic manipulation or like design. So my first question would be, how do you see like the evolution perspective? How much of it is controlled, or how much is designed, or from a more complex system perspective, how much is just like the evolution of this system?
Yeah.
And the second question is also my question Simon's framework, of course. So how do you distinguish what makes this normative kind of realm that is special from the software, from the linguistic?
So I have again my slides. Yes, thanks. So 1 second, because I returned on the slides that I was taking also from Michael. That's at the very end, so I need to touch a lot. But it's about the difference between primary and secondary driver. Essentially, that's in the paper, and I had a slide as a backup about that. Because indeed, there is a moment in which you're deciding in your system what is hard-coded into it and what is guided. So, and that's a design choice, and that depends very much on the application that you're considering. So you could say that humans, we have a component in ourselves, like survival, all these kind of things that are biologically evolved. These are kind of primary drivers. I mean, we can even override them in certain situations, but I mean, we could consider them to a certain extent primary drivers. We come with that. It's a legacy of how we are being built up by evolution. But on top of that, we have all types of socially constructed norms, like parents, teachers, societies that have been put that into you. So that's something similar. Whatever technological device you're considering, there may be a threshold between what is considered to be a primary drivers and what is going to enter into the realm of secondary driver. So it's a decision. An internet, that means that perhaps you could enforce to have this principle to be primary driver. So that means that the rule, you cannot modify that anymore. The criteria of giving access in the right point or giving fair distribution, they could be written as primary driver within your system. They cannot be contested or cannot be overridden. It's a design choices. But first of all, we need to have, again, conceptual tools in order to reason of technology in those terms. And that was, the main purpose of this paper. So, I don't know whether this answers a little bit to your question.
Yes, we have the whole lunch to answer that question. This is absolutely fascinating. I'm going to read you a question from the chat. And two questions together. So one question from Rebecca Mignot-Madavi. I would also be interested in hearing, Giovanni, more on opportunities for contestation, but also for disobedience. Following Mireille and Helen's exchange, that's another chat. Concrete, tangible examples would be very useful. So if I translate contestation after the fact, but Roger Brown's word, for instance, is talking about disobedience. If there is a law that you cannot disobey, it's not law, it's something else. There's nothing wrong with it being something else, but it's not law. So she's asking, can you be concrete as to Normware, as to the very interesting and I think important combination of descriptive, interpretive, and normative strategic dimensions in terms of disobedience. So contestation, I think, would be nice to have an example, but more nice, could it be disobeyed? Example. And the second question, I'm just going to tell you because it's related from Bernard Keenan. Does Giovanni think we test this with human perception, or a more cybernetic approach of, let's say, communication, or perhaps even artificial communication?
Yeah, no, thanks for the question. Indeed, they're going into very practical aspects of where this vision is going to. I have to admit, this is just a vision. I'm trying to make sense of all the things that I'm seeing around, again, both on the computational and on the legal side. So allow me to have also some space to reflect more into that. With respect to disobedience, so in the sense that my answers are not definitive. Again, these are contestable. Also my answer, I cannot say that I believe in them as golden truth at all. So the disobedience, at least as far as I'm seeing Normware, that again, it's a design level. So it's about computer. It's not about humans. So indeed, robots may disobey to the orders, if that's one of the secondary driver, if that's a directive that has been given to him and it's going against some other driver, which is stronger than that secondary driver, it can disobey, sorry. I should use not the personal form. So it's something that in the system is allowed as far as depending how much autonomy we're given to the autonomous entity. So this is something I can see as possibility. But there may be situations in which you don't want machine to disobey on certain aspects, and then you're blocking them from doing that.
Is Normware only between machines?
No, it's not only between machines. The question is that there is an interface, no? So you could say even a program is an interface. I'm writing down, no? So I could write down a very simple sentence, say, do that, or it's an instruction. So I could tell to the robot, do that, very simple instruction, and for whatever other reason, because my directive is a secondary driver within all the system, is just disobeying. It is just disobeying to it. So it is possible. But it's not the same type of thing that I can imagine with respect to disobedience, with respect to an institutional system. You see, so we're talking about different type of concept here.
Because the question is, I think, whether humans could disobey the normative.
Yeah, but Normware doesn't apply on human directly as norm. So as I said in the first slide, again, it depends how you define the infrastructural structure. I said this should be the lowest level of courts. So any other human court or any other legitimate normative source should be above it. So it's kind of, rather than thinking they're taking over, we are creating space for down to fill in when it is needed for complex systems or things like that. But this is my view. This may be also abused as a technology by inversing the...
Of course. So the second question about, so at some point the effects are going to touch human beings because that's our interest. of
Yeah,
course.
indeed.
So how are these human beings going to interact with these systems, and where does the disobedience, one, and the contestation sit in the interaction between, let's say, the normware and the human? Because even if it's
No,
derivative-
indeed. But so if you remember where the three dimensions that I was identifying as fundamental in normware were regulation, so of behavior of situations, so that you're telling where you would like to go or not to go. And then there is something about terminology, and then there is something about expectations. So these three things needs to be the interface. So that means even humans may be needed to say what are the terminology that they're using, what are the expectation they're having, and even the fact that they are feeling something, or I mean, this kind of tracking what the humans are feeling around you, this is something that you can build if you have the correct type of normware to be there. But it's, I mean, again, these are very much implementation choice of what type of normwares are you setting up into the machine. We are here at the pre-stage. So can we define? So let's say the question is, does it make sense to define another design stance besides normware, software, sorry. And my argument is yes. But again, that's arguable as an argument.
Okay. Then I suggest we continue the conversation over lunch. And I understand that, and thank you very much. Let's again.